Welcome Dr. Shetty to yet another episode of Editor Speaks. Let me begin by asking you, sir, for an intervention, is a consent valid for its alternative or extension as well?
See, let us be clear, every intervention requires a consent. It has to be clear, it has to be specific, and it has to be separate. If there is an extension involved, the consent has to be separate and a different one. If there is an alternative intervention involved, the consent has to be separate. This is a general rule of consent applicable all over India.
Any exception to this general rule, sir?
Every rule there has to be exceptions. In this case, there are two. One, an emergency. Two, if the patient waives his right to be told about the intervention.
However, a recent judgment from the Madhya Pradesh State Consumer Council has ruled otherwise. The court has ruled that a consent taken for angiography also covers angioplasty. Your views, sir?
I have read this judgment from the Madhya Pradesh State Consumer Commission. In this case, a patient with multiple comorbidities was brought to the hospital with breathlessness, chest pain. The patient was transferred to another hospital for better management. The other hospital performed a angiography and subsequent angioplasty. The patient developed complication, died of septicemia. The relatives filed a case of negligence. They made many allegations. One specific allegation stood out for me. The relatives allege that based on a consent for angiography, angioplasty was done. The court perused medical records and specifically pointed out one clause in the consent form, and I quote, "I give consent for any change in the anesthesia or operative procedure as well as for the removal of any organ as may be deemed fit and necessary by the doctors at the time of medication, investigation, operation, therapy, procedure." Based on this clause, the doctors were held not negligent by the court.
So then, is this not an exception to the law relating to general consent?
In this case, this clause the court accepted as a consent for angioplasty, but this may not be the case always. It is always advisable for a doctor to take a separate specific consent. This kind of clause in a consent form is known as a blanket consent clause, but this may not help the doctor in every case. It is advisable for the doctor to take a separate consent.
Your final take-home message for doctors. What should they be doing in such kind of situations?
First and the foremost, doctor should be very clear. A doctor may have a bad day, a surgeon may have a bad day. Anticipate complications, anticipate failures, and hence it will be advisable for a doctor to take a combined consent. In this case, had the doctor taken a consent for angioplasty specifically, he would have had faced the problem. For a surgeon performing a laparoscopic surgery, there is bound to be someday a laparoscopic failure. It is always advisable to have a consent taken for an open surgery. For an obstetrician who has planned a normal delivery, it's always advisable to have a cesarean section consent ready, and so on and so forth. The guidelines for consent are very clear as per the Supreme Court judgment which has been given in the Samaira Kohli versus Dr. Prabha Manchanda. The guidelines are very clear about how a consent has to be taken. Exceptions are always there, as discussed earlier. An emergency is an exception. If the patient waives his right to know about the it is an exception.
Thank you, Dr. Shetty. This was a wonderful discussion where the insights given by you will definitely be well appreciated and accepted by doctors, specifically in cases where they have to extend their surgery and look beyond patient consent. Thank you once again, sir.
Thank you.